So, Brittney's been here and has spoken in the past, and she is absolutely amazing. And copyright is such an important subject to artists of all type. What is mine? What is somebody else's? What do I do if I think somebody stole something? The laws are constantly changing. The internet is making it even more confusing. So this is one of her firm's area of specialty. And so we're excited to have her. I will give a side note. She is battling a throat something. So if she sort of waves and says, "Jerry, I'm going to whisper in your ear, you're going to start talking for me," we're all going to be very forgiving because we just appreciate her being here. And what else do I want to say except for the fact that I have referred her to lots of people, and everybody that she's talked to has been very, very happy, and so we're really excited to have her back. So I'm going to shut up because you didn't really come here to listen to me. You came here, so let's give a warm welcome to Brittney Maxey.
Yeah.
All right. So I do apologize that I'm not feeling 100%, but I wanted to make sure that I was here for y'all today. My name's Brittney Maxey. I'm a patent attorney that does patent, trademark, copyright, trade secret. And I have an undergrad degree in pre-med biological science. So first I was going to be a doctor, then I decided to be a lawyer. And it's an interesting, cool area of law. So have any of y'all applied for patents here? Anybody on any sorts of tools that you may use in any of your...
My dad did, but
Okay, all right, cool.
I tried to, and it got really confusing.
Okay. So I am going to do a brief overview of the different areas just to get started, and then we'll go more into the copyright realm. What about trademarks? Has anyone applied for trademarks here? Copyright, has anyone done the federal registration? Okay, all right, very good. Trade secret, any trade secrets? Formulations or chemical compositions or some sort of food recipe, that's typically trade secret. So I would venture to say that before you guys all came out here today, all of y'all experience intellectual property in a different way. Whether you woke up to your iPhone waking you up with an alarm clock, you know, that actual device has a patent on the shape of the phone, and then it has a patent on the alarm system itself. So obviously patents protect more of either the look of something, like let's say for instance the Coca-Cola bottle, the 5-hour energy bottle, a mascara wand, all of those things can be patent protected. Then maybe after you woke up you grabbed some Tropicana orange juice. Tropicana is a trademarked brand. Okay, that's what trademarks protect. So if y'all have a business that sells any of your artwork, most of the time you're going to call your business something. The name of that business, you know, you need to register it obviously with the state of Florida, but then the brand identity behind it can be protected with trademark. So I'll get into that in a little bit. Then maybe you flipped on your television and you were able to watch Bay News 9. Well, that's a copyrighted broadcast. Yes, art, photographs, websites are all copyrightable subject matter, but so are things like copyrighted syndications, such as theatrical productions, plays, pantomimes, all of those things are things we can protect with copyright. And then maybe you ate some sort of Krispy Kreme donut or Twinkie, or maybe a piece of KFC chicken. And I say those three things because those things have trade secret formulations with them, okay? So intellectual property really is much broader than what people typically think. And I just wanted to quickly explain those three areas. And when we're looking at IP, it's a very creative area of law, like I was just explaining. What IP regulates is the ownership and the use of those creative works, which it doesn't matter if you've come up with a hand tool or it's a photograph or a piece of art or a trademark. You need to understand, do I own it? Do they own it? And am I giving more rights away than what I should be giving away? It's a very, very important piece when we're looking at intellectual property. Yes.
Can we get these?
Yes, these.
So we don't
I was
have to
gonna
be
say a
scribbling
disclaimer.
here?
They're black and white because I took all my fancy stuff out. So I'll send you the fancier version, or I can send them over to Jerry and she can get them to you guys. So yes, we'll send them over. Also, I would love questions because I know that all y'all want to know something different. So as I go on, if I think it's too complicated a question for the time, I'll just get get your email after and we'll link up after this presentation, okay? How's that, Sharon? Good?
Thanks.
Okay, so this is actually, I just wanted to show you guys what an actual patent grant looks like. This is the ribbon copy that you get from the government after you go through about a 3 to 6 year battle with the United States Patent and Trademark Office. All the areas I'm talking about today are all federal areas of law, which is really cool because we have clients in all different states. If you were to file a patent or a trademark, you file it at uspto.gov. They do electronic filings. Also, if you want to do any sort of research to make sure that you're not stepping on someone else's toes, you want to go there as well. So after all of your battle, and I say 3 to 6 years because it depends on the area of technology that you're in. Obviously, a catalytic converter is going to be a little bit more complicated to get a patent on than maybe a spork. So that's that spoon fork thing. So it really depends on that area of technology. Now, this is what a trademark registration looks like. And again, this is a right granted by the United States Patent and Trademark Office for that brand identity. For instance, if we think about Starbucks, Starbucks, their very first logo was very different than the logo they've got today, and they had the word Starbucks with it. Well, now Starbucks has a copyright on that artistic expression of that logo, and then they've got a trademark too. The difference between the trademark and the copyright for Starbucks is all of the art that you see here today doesn't have to be tied to a good or service in order to be copyrightable. It's just the fact that you took something and made it into a mean of expression. If you want to get a copyright on it like Starbucks did on the logo, it has to be tied to a good or service. That's the difference. You can do both, and it just depends. We talk to the clients about what's the best way to go. And then this is what a copyright registration looks like, which I know that you've gone through that process, and that is through the United States Copyright Office. The copyright, the ECU has, that's usco.gov. It's got a little E at the top of it, and it's got a really nice tutorial that if you do want to apply for a copyright on your own and not hire a lawyer, it walks you through it really nicely. I really think of all of the areas, the copyright is the best tutorial that you can get. So we'll go a little bit quickly through the patent, but I just wanted to show you a design patent because design patents protect a lot more than people think. That's the design patent for the Oakley sunglasses. It's literally on a shape. The fact of having some sort of glass or a rim that holds a piece of glass that you can see out of and shade your eyes from the sun, that was done way too long ago. So you couldn't obtain patent protection on it now because patents only last for 20 years from the filing date. However, with the design, that was cool and unique at the time, and so they were able to obtain that design patent protection. One thing I wanted to say about patents really quick is if you ever wanted to get a patent, a lot of times people say, well, Brittney, I need a patent in order to use my invention. That's not the case. A patent gives you the right to exclude someone, okay, from making, using, or offering for sale something that is too similar to what yours is. And again, all of the areas of law that I'm talking about today are federal. They're also limited in time and they're limited in geographic scope. If you get a patent in the United States, it's not going to stop anyone in Australia from making your product. It's when they import it into the United States that you could stop them at that point. Same with trademarks, same with copyright. Patents, like I said, last for 20 years from the filing date. Trademarks last for 6 to 10 years, and then you have to renew every 10 years thereafter. And copyrights is 70 years after the death of the artist. Everything 1978 this way. Jerry.
There was something, and you guys help me if you're familiar with who it was and what it was. And I don't know if it was a patent, a trademark, or a copyright on shooting a person on a white background.
Yeah.
Can you speak to that?
Yeah, so actually I think it was Amazon
Yeah.
that applied for a patent for that. It's quite interesting the things that Amazon and Google file for patents on. Google just did a patent on a brown paper bag. I still don't know how they got it through. But the white background, they actually got it quite far through the patent office, and then a company did what's called an inter partes re-exam, and they said, wait, that's not really patentable, and so they canceled the patent application. So that's a good thing, because it was quite odd how that whole thing went down. So one other thing I wanted to say about patents is As soon as you file the patent, it's called patent pending. So if y'all see any products that say patent pending, it doesn't mean it's patented, it just means it's going through the process. But sometimes it's a good marketing tool, you know. So if any of you guys ever come up with some sort of tangible invention, like a new paintbrush or something of that nature, you would want to go for patent protection, okay? All right, so let's quickly look at trademarks. Like I said, no matter what your business is, you know, just like with my business, I still have a name of it. So a trademark is a word, like Gucci, a slogan, just do it, or a logo used by a person in commerce to indicate the source of the goods. Trademarks go all the way back to when blacksmiths used to create their swords, and they would mark on it, you know, your initials or something like that. That way you knew when you bought that sword that it was created with the same quality that that blacksmith always created his or her swords with. So that's where trademarks come from. A pretty cool thing is you can get a trademark on a sound. Dun dun dun. It sounds terrible today, worse than it already sounds typically. Anybody? NBC. Like, you know, when you hear that, or the Intel computer, when you open it and you hear it start boot up, those are actually trademark sounds. Harley Davidson tried to get a trademark on the roar of its engine, but it couldn't. They said it wasn't unique enough. Another thing that's not up here that can be trademark is color, but the color can't be tied to the function of what the brand does. So for instance, those nice shoes that cost about $1,000 and have a red bottom on it that Christian Louis Vuitton makes, that's a trademark, and that was a really great idea because Yves Saint Laurent, another big fashion house, tried to knock it off and wasn't able to. The issue with color is, again, every shoe has a sole, but they're not all red. So it was literally that when you see those red bottoms, you tie it to his brand, and that was the important piece there. Okay. You know, here we've got the Tiffany blue box. Actually, Tiffany's another one that they have a trademark on the color itself. If you go to buy a cake at some cake stores and you want that color of icing, unless they license the color, they can't give it to you. So it's very interesting. And Tiffany just had won a big lawsuit with Costco because Costco had a line of rings that they were calling Tiffany set rings, and it was a big deal. Tiffany fights hard. So again, I'm telling you guys about trademarks so that you know with your business. Here's my slide with a logo, a word, a phrase, a design, a sound, a color, or a combination. These are all goods, but it can also be for your business name. You know, if whatever you do business as, that can be your brand identity. One thing, y'all probably don't have anyone create logos for you because you're all artists, but if you did have someone create a logo for you, remember that the rights lie with the creator. So even if you asked them, paid them, told them what to draw, you know, from a logo, like maybe you do oil paintings but you're not a graphic designer, that graphic designer owns the rights in that trademark if you don't have it transferred over.
Well, what about works for hire? I thought if somebody was hired and in the contract it said work for hire, then that was the language which transferred it over.
Yeah. So the works for hire are a special case, and they are more applicable with the copyright piece. If we're talking about a logo, they really fall more under the trademark. So a work made for hire can't be a trademark. It's more of a copyright type of piece.
Gotcha.
What could happen is, in most, like when you hire most graphic designers or website companies, they have language in the contract that says, I own the rights or you own the rights. If they don't, you can do a simple, what's called an assignment agreement, and it's a very simple document, and it just transferred the rights over to you.
So a lot of the people in this room are photographers. So let's say a photographer shoots something, they get a model release saying that they're allowed to do that, and then the model or the client takes, let's say they burn them a CD and they take the images, the photographer still owns
Absolutely.
the rights. So they don't have to have language that says the photographer has permission to use it for promotion or something like that.
The person that snaps the shutter is typically, you know, the creator is that's where the rights are typically going to go back to, unless there's some sort of special circumstance. When you have a model sign a release, typically you're just saying, hey model, I'm going to take a picture of you and you're not going to sue me for, you know, using that picture later. So it's a little bit of a flipped situation. But if the model then went the other way, you could definitely say, hey, those are my photos and I didn't give you the right to use them.
Okay, so question.
Yeah.
So you're somewhere and you're out on the street, and there's a very interesting looking person who you have no clue who it is, and you take a picture of that person, and then you want to publish that picture. Do you need a release from that person?
I do think you do. I know it's like a very, I mean, the reality is would that person ever come back and probably try to sue you? Not unless it gets to be a famous picture. And then you're going to have an issue. And so we all want to, you know, be very successful. So I just always say that I want those kind of releases done. That's my take on it.
Somewhere in a class that I had back at St. PJC, they actually explained that, and they said that if you were out on the street in a public place, you are fair game.
I had a friend that actually just contacted me, and he was like, somebody sent me this picture of me sitting over on this harbor that some photographer took of me and recognized some of the photo, and he goes, what do I do about this?
Yeah.
I feel like he was the subject in the photo and he didn't know what to do.
Yeah.
And I was like, listen, you are out in the open, I don't know what to tell you.
Yeah.
Like, you can contact a photographer and introduce yourself to them if you want to. That way they know that you know that it's out there, but
it's
not
fair
really a
game
lot.
to an extent, but then we all have a right of likeness, and it's not an intellectual property area of law. It's more of a tort, you know, right of publicity, right of likeness, and right of privacy. So it's fair game to an extent, but I really just say to be the most safe, I think you should go ahead, because I think if he were to you said it was a guy, right?
Yeah.
If he were to contact the artist, I think there would be some issues there, or the photographer. I'm sorry. Yeah.
Would it make a difference if you are out of the country and the part of your shooting is in
So yeah, what I'm talking about right now is just U.S. law only, because like I said in the beginning, every geographic location has a different set of laws. Now we are party to what's called the Berne Convention, which is an international treaty for copyrights, and most other areas of the world are a lot less formalized in their protection than we are. So maybe it's okay in other areas, and it depends on what country you're in.
I just thought about how complicated one point, because I did the artwork, the relief tiles on the outside of the building in Miami. And then what happened was other photographers were taking pictures of the building of my sculptures that I made and selling them for huge amounts of money. And when I tried, now I kind of felt a little violated with my sculptures that they were photographing and making huge amounts of money. And then when my work appeared in books, if I tried to photograph by other people, if I went to a place to have it reproduced, they would say I can't because I wasn't the photographer. But it was my sculptures.
Yeah, it becomes very, very gray. But I think on the merchandising question, did you ever get a lawyer or anything? Because I think they're wrong there.
Well, I can introduce you to a good one.
I think they're wrong there, especially on the question of the public. You know, it's out in the public. They're taking a photograph. So what happens is you own the rights in the sculpture, the copyright rights, but they own the rights in the photograph, but it's not giving them the right to reproduce and sell merchandise. Because it's a bundle of rights. That's how I see it.
And is that the same way it is, like if you are taking a photograph of someone in the public, if you go to reproduce it and sell it, that's when you have an issue?
Right, you're exactly right. Is when you think of copyrights, it's not just one right that you have. You know, I've got a slide on here. It's a right to reproduce. It's a right to publicly display. It's a right to reproduce, to do derivative works. There's several rights that are, I like to think of it as like a bundle of sticks. And just because one person holds one stick doesn't mean they have the other ones. And so that would be the thing, is you couldn't go and say, I want the copyright in the photograph that you took, but they can't just make merchandising out of your sculpture. That's how I feel about it.
Is that called fair use when one person takes a photograph of somebody and doesn't ask permission, but they hit it for themselves only? That would be considered fair use then?
Yeah. Fair use is a really small defense. And fair use, the best place for fair use is for satire, like what Saturday Night Live does.
Okay.
For commentary, if you're like a news organization and you're commenting on something, or in the educational realm. Those are really the biggest things for fair use. It's very, very rare that you'll be able to get away with some sort of fair use argument. a lot of people say, well, Brittney, what if I didn't sell it for money? You know, I'm just using it, and nobody cares. Those are the only times that I like to see fair use, unless it's something pre-1923, because anything pre-1923 is in the public domain.
But they say you can duplicate your videotapes, so that was considered fair use. But that's not the correct term to use at that point?
Right. So there's a derivative work, but yeah, fair use is, yeah, it's very limited. Just think very, very limited on that. Jan?
I wanted to reference something that was asked earlier. If you've ever purchased something under royalties, then you'll know that it has different prices based on how many eyeballs are going to see it, and what kind of a public or private space it's going to be, how large it's going to be, an image that's shot for a 2-page Time magazine spread as opposed to a 3-inch by 5-inch ad. And if you go back to thinking in those terms, it kind of gives you a structure and a context.
Can we just like bring it to something small, like just like I want to do pet portraits, something simple. But as soon as I did like a portrait for somebody, I told them what it would cost to have it reproduced, and I had copies made here and paid a large sum of money to have the copies made. And they just took it to Kinko's and ran off a bunch of copies and said, oh, we don't want to pay that much money. And they just ran them off at Kinko's. Who's to stop them?
Did you have them sign a contract when they hired you?
Not to do that? No. It was just, like, here, here's a picture. Okay, let me write a check.
You know, and you have to.
Yeah.
That's where you get them to release it, right?
Yeah,
That's where
I mean, and I get it that it's like, well, I want to do the art and the photography. I don't really want to worry about all the legal stuff. But the thing is if you do decide to go after them at some point,
well, I can't do that, but I don't want it to happen anymore.
I think that you should have some sort of it can be a very simple 1-page agreement that says, this is what I'm allowed, this is the bundle of right I'm giving you. I'm giving you the right to reproduce it in this mode or medium, nothing else. And it's more of a very limited, non-exclusive type of right, okay? It doesn't have to be a big contract.
They're going to take it.
They may.
They're just going to fold that into their thing. They're going to go away and they're going to go to Kinko and get it reproduced.
Well,
They may,
some places don't allow it, like Sam's Club.
You
You
have
have to sign a piece of paperwork that says you are
I
a
have the
photographer. Because I've had to do that for school.
Right.
And anybody that I photograph, and I give them the paperwork and all, because I've been stopped several times, I give them a piece of paper saying, I give you the rights to do whatever you want with it.
Right.
After I'm done with them.
Yeah.
You just sell all the rights to it.
Yeah, because
You
people
might as
I've done
well,
it for
if they're gonna
friends,
do it.
family, and things like that.
And that's
So-
you could charge a little bit more and say, and you get all the
Yeah.
rights, I guess. I don't
It's the
know.
only way to get around it,
That's
really,
what I do.
because
I
there are
say-
certain things like
I mean,
that.
because you
know,
can't,
can I use
all of
something
these
more?
kinds of intellectual property, you have to enforce it, and that's the thing, is you want to make sure that you're protecting yourself as much as you can, but unless you follow all of your clients to wherever they're going to go have these copies made, the reality is, unless you're going to sue them, what are you going to really do?
I know.
And you've had your hand up for quite a while, and I'm sorry to point, I just don't know
That's
what
okay. I just want to ask a question about department store display windows.
Mm-hmm.
I was photographing mannequins in the window and had a security guard come out and say, you can't do that. And when I was in school, I'd heard that it was considered public domain.
Mm-hmm.
And I didn't look like a professional. I had a cheap point and shoot camera. I said, I'm a tourist. I just like the way these look.
Mhm.
And he said, don't take another picture or I'll bring the cops in. Was he just calling my bluff, or could they actually keep me from
If you were in the store, it would be different, but
No, I'm on
storefronts
the
that are
sidewalk.
transparent are
thousands of other
yeah.
people?
That's small
That's-
policy though, because
yeah.
I got in trouble at Countryside for shooting video in there, and it was like a school project in high school, so it wasn't like we had little crappy
It was
cameras.
obvious you're a
And
teenager.
yeah,
and-
they're like, that's the rule at the mall, that they don't allow people to take pictures or video because they don't want like the look of the mall, or I don't know what the
Yeah.
heck it is, or like I don't know if it's security
I mean,
reasons, but
that's-
that's the rules of the mall specifically, not.
when you're inside, I think they can have some of those policing mechanisms, but if you're outside on the sidewalk, I don't see how they can do that.
You just tell them to call the cops.
Yeah, he was like 300 pounds.
Definitely, they would be like, I have no idea. Let's call a
Take pictures of
lawyer.
them while they're arresting you, and then you have a
Golf
story.
course,
You
yeah.
get famous.
That's just funny.
Share.
But Brittney, there are certain buildings and other things that actually have copyrights on
There are.
them.
There
And
are.
you're not allowed to photograph them for any public use.
There are.
So you
Yeah.
really have to be
I
careful
would think
with
that a
that.
storefront,
posted, though.
yeah, with a
It's not always posted. I think it's like the Flatiron Building in New York, I think that one's copyrighted, and there's a bunch of others like all over in different countries that are copyrighted. So if you take a picture of it, it's for your own use, but if you wanna use it in
Oh, like,
something
yeah, like the
else,
building that I did, right.
and it's copyrighted, you will, and if you publish it, you will get a cease and desist from them, because
Or a
they're very
$10,000
scrupulous about
fine.
it.
I
Yeah,
did,
something.
I didn't,
Yeah,
yeah.
you have to be really
I think
careful with that.
storefronts, leaving out the branding, I did want to circle back to that really quick. The branding is a different thing. So if you had, you know, the branding, any sort of, that's why like if you watch Food Network or any cooking shows, they never show that it's Heinz ketchup or whatever, or Hunt's, they always block it out because they don't want to pay for the licensing on the branding. So I think when you start, like if you took a picture of Tiffany's with the sign, I think that's a little bit different. Maybe that's what they thought you were doing. I don't know.
If it was a Bloomingdale's
Yeah.
department store.
Okay.
we didn't
And
do
they
it
aren't they
here.
the ones that do the famous storefronts every
Yeah.
year for the holidays?
Oh,
So
yeah.
maybe
The
they've
best
got something
windows.
there. I don't know.
Shop somewhere else.
Yeah, there you go. There you
Storefronts are pretty awesome.
go. Yeah. What was your question?
Yeah, so when you sell your art, obviously
It's
you're not
a
selling,
boycott.
you retain the copyright, but, the owner of the original work that you sold them cannot take a photograph and sell your image, right?
Say it again.
Let's say you sell, if somebody buys my, painting,
Mm-hmm.
they can photograph it and sell it, so, can they?
They can or cannot.
They
I'm
cannot,
sorry.
I mean, because
No.
when you sell your original piece, you own, you have the copyright, the
Right.
artist has the
Exactly.
copyright.
Yes.
So
Exactly.
the owner cannot photograph it and sell copies of it.
True.
Well, they shouldn't.
That's true.
Cannot. They cannot.
Yeah.
Yeah. Sorry, my ears are a little clogged. Did you have another one?
I just thought about something what Ross said. I had, this was probably 10 years ago, I had sold an original to a client, and a friend of theirs said, "Oh gosh, I love that picture. I own a swimming pool company.
Mm-hmm.
Can I, I'm doing a calendar, I want to put that on the cover of the calendar, do you mind?" And my client said, "No, go ahead." And it wasn't until, you know, the holidays that I see this calendar, and they were giving them away and not selling them. And I
Send them
could have
an
done
invoice.
something about it if I had
Yeah.
felt like it.
Send them an invoice.
Mm.
It's not too long. It's not too late.
Yeah. Yeah,
Well,
it doesn't matter. The money, whether someone's giving it away for free or not, that's not one of the hurdles. It just doesn't matter. They shouldn't do that.
I had called at that time like a free legal clinic, and they said I'd have to sue my client because he's the one that gave permission to his friend to be able to reproduce it,
You
and I
can-
didn't want to ruin the reputation with
I
my
have a lawyer you
client.
can talk to.
Yeah. Yeah, I think, you know, when we're suing, we're looking to sue as many people as possible. Honestly. So I would probably go for both. You know, I don't think you have to go through your original stream. Yeah.
If we wanna go,
Sorry. Go
Yeah,
ahead,
so
and then I'll go
I
back.
just wanted to circle back, just get some clarity on, shooting out of the country, people.
Yeah.
So, what's the deal with that? I
Yeah.
mean, how do
Let me
we
see
manage
how-
that with,
Because I do have some stuff about burn in here.
oh, she's gonna do a presentation, we had to.
You know, if you look at the travel shows, they're showing private people
yeah,
that they've not necessarily set up
yeah,
as models
right.
Brittany,
for,
I'm gonna piggyback
for
on
tape.
her
Yeah,
question while
yeah.
you're looking at that. I'm going
I mean,
down
do
to
they get a
Rio for
release from
Carnival,
every single
and I'm
person?
gonna be taking a whole
Crazy.
lot of pictures
Yeah,
of people
I
in
mean,
that
and they've got
parade.
Listen,
the
for- I wanna
market
read the
square
news.
in Denmark, you know,
So can I not
Copenhagen or
sell those
whatever, and
pictures because?
you've got all these people on film, and
Do you want?
you can't get a release from
Oh, I'm
all
just,
of
yeah,
them
it's the next
to
one.
use their
Yeah, I was just,
image.
I wanted, I
Yeah,
had
so I don't know what point
stuff
that
on international.
the copyright kicks in, you
Because
know?
I don't
I
know
know,
that
I'm
With
curious,
the
'cause I
permission we
have a
have
lot of
to-
portraits of, you know, people in India and France and places
Yeah.
like that, that
If it said anything about
Yeah,
it.
and
They
you know,
probably
with the
never
internet,
see
of
it.
course,
Your water?
there's
Yeah, yeah, thank
images
you.
everywhere, you know, I mean, the accessibility to photos is just
So
so
Okay.
Just read that.
tremendous.
And I'm like trying to read it too. Because, you know, I practice law in the United States, so some of these things I don't know, but I was wondering, you know, this is talking about the Berne Convention. You know, we became a party of it in 1989. I was trying to see if there was anything about people. The result then is that a United States author automatically is entitled to protection against the infringement of his work in a foreign jurisdiction that is a member of the Berne Union. So that's more talking about y'all going that way. The U.S. author does not have to register. Yeah, most of these things are country to country. So she's asking about Rio. And that's going to be very specific to Rio. To where, what country are you asking about?
India.
India. It's very, very country specific. I think most of the slides that I've got on the Berne are going to be talking about if y'all's work were to get taken, then that. I can look I've got a lot of contacts actually in Brazil and in India and let you know. So it's more with people on the street if I take
Well,
a
the
pic.
carnival, you know, I mean, there's a huge parade and they're all in costumes.
Yeah.
And
Yeah, I know. I
Well,
want to go
if you
there.
can't recognize their face, I think that's
That's
completely
interesting.
different. If they're, I mean, you know,
That's
they
what I
have
always understood.
masks and things and feathers and whatever.
Let me
You
look
can
at
see
the
it.
any
Right,
other
you can't
countries
see
or
them.
just
Yeah,
those
so
two?
one of
some
my
of them
friends
you
was in
might
Ireland.
be able to, some of
Ireland?
them
Yeah.
not, but I don't
Oh,
know
the
if
one on
like
the
the
waterfront?
costumes
Yeah,
are
yeah.
copyrighted.
I do
Oh,
know that other
or-
countries are not as strict as us, but I'll have to let me look into
Who
that.
knows?
Yeah, you gotta do
I
some
mean,
street
there could be
photography
certain
on,
companies that
you know, how
have-
you gonna do street photography
I
if,
don't know.
Well, then that's the other thing. Even if you had the person just sign or some sort of release, you're not going to have jurisdiction over them anyways. So it's kind of like really what could come of it, and they're not going to have jurisdiction over you. It's kind of an interesting type of thing. Of sometimes we're just the I don't want to say common sense, but how would they sue you? I don't know. How are they going to get
I
jurisdiction?
think galleries now, they want you to come in with your photograph with the release, you know?
That's true.
Yeah.
Now that's a very good point. Like for galleries, yeah, very good point. Yeah, I was thinking more just not for gallery.
Yeah.
So are patents, trademarks, and copyrights, are they medium specific? In other words, I do woodwork,
Uh-huh.
and one of the things I do, it's a small horse-shaped, hand-painted with horsehair, mane and tail,
Uh-huh.
on casters
Mhm.
for young children learning to walk.
Mhm.
And in all, I've tried to search it to see if anyone else makes anything like that at all.
Uh-huh.
Can't find it.
Yeah. Okay.
And so when you find something like that no one else, you do a Google search and find everything and anything out there that might have casters
Mhm.
on it for kids, and you don't find anything. I mean, anybody can make that. It's hand painted on the face and everything, so it can't really be duplicated unless they buy one,
Right.
make a template, and make templates for all the pieces and then make it themselves.
Mhm.
But how does that kind of a thing, we've been talking photography and
Mhm.
permission for
Mhm. Mhm.
private people's photographs
Mhm.
and things. How does product
Mhm.
come into this
Yeah.
and it may even be applicable to the photographers here because of frames and wood and things that if they make some frame for their photography that is totally different than your standard frame or whatever, so
Yeah.
how does that,
So
I mean, you've got the company name and
right.
I like to brand my company name onto the piece
That's
with like
good.
a wood burning
Yeah, that's
type
good.
thing.
Kind of like with blacksmith.
Yeah, that if it doesn't have that, it's not mine.
Right.
But still, it can be duplicated.
Mhm.
But where would that fall within
Yeah.
these three different
So-
areas?
When you do Google research, I think one thing to also keep in mind is Google research is just things that are out in the marketplace. It doesn't necessarily mean it's everything that's ever been invented or thought of.
Yeah.
So that particular item itself, the horse, right? It could have at some point potentially have had patent protection on it. So, but the inventor could have died, ran out of money, said they didn't want to do it anymore. I wouldn't think right now, unless you had some sort of very unique mechanism of attaching the caster to the hoof of the horse, there could be some sort of functionality or structure there for a potential patent. But just remember that if you're thinking about patents, Google research is one thing great, but go into your Google toolbar and type in Google patents, and it takes you to the patent database, which is where you need to be looking at. So I bet if you go in there, I bet you'll see a patent from maybe, I don't know, the first patent on a contact lens was like 1890. So you may see a patent from way back. However, so I don't think it's potentially patent protectable.
20 years.
Yeah, 20 years, yeah. But it could be potentially copyrightable under a sculptural work. I know it's not a traditional.
Because it's all hand.
Right.
Each one is different.
It's not, right.
Each one is different.
But it could be protectable under a sculptural work. Because I've seen things, I know
would
wax
that be under
designers.
the patent?
Copyright.
Okay.
Copyright, yeah.
Okay.
I know people that hand dip candles and they, do it in a certain manner and it comes out looking a certain shape, and they've been able to get copyright protection, and the Copyright Office says, you know what, that's a sculpture. So yes, we've got traditional sculptures, but think a little bit outside the box as well.
Yeah, because this really is a sculpture, pretty much, the way it's made. And
yeah, and with the other cool thing about copyright versus patent is patent, it has to be pretty unique in order to get a patent, to whereas copyright, as long as it's got a modicum of creativity, which would be the spin that you're putting onto each and every one of them, you would be able to get that copyright protection. If you file, though, it's very particular about how the angles of the photographs that you take, because you can't send the horse into the Copyright Office. You've got to send photographs, and you need to take them from each angle and do the application in the correct manner. If not, you'll protect your photographs and not your horse.
Okay. Now, I just had one more
Okay,
question.
I was going to ask you on yours. Doesn't he need to have a model to submit? Don't they have models?
You don't have to submit a model. They accept photographs on sculptures now, but you have to do it in a certain manner.
But you get all the angles.
All the angles, and when you're filling out the application, you have to make sure that you click the right boxes. If not, they'll just say, oh, they want a copyright on the photo.
Yeah. Now, is an idea copyrightable or patentable, even if you can't create what the end result would be?
Broad ideas are not either one.
Let's say it's a electronics, automobile related thing.
So copyrights protect the expression of the idea in a tangible medium. So it's that expression of the idea. That's how source code and software is able to be protected. Patents protect the structure of something based upon the function. So the idea of something electronic on an automobile in and of itself is not protectable. It's how the thing is put together that makes it patentable.
Yeah, so you really need to have
you don't have to have a
not
working
only the
prototype.
idea, but you have to have the end result of the product
Right,
of what you're
because when we
thinking
draft
of.
a patent application, you have to explain to the patent office in enough detail how to make and enable someone else to use the invention. That's the whole thing. As it's like in the patent, you give everything up. You tell someone exactly how to do it, and then if you go trade secret, you tell them nothing. So you can't do both.
Gotcha.
Yeah.
Thank you.
You're welcome.
What is, I don't know how to ask this, but basically if there's, let's say there's a picture, like a movie poster, and then you have a bunch of artists who do like their own rendition of it, like they remix the poster, so to speak. Can the artist who creates a piece based off of a photo, a movie poster, or something like that, could the artist get in trouble for doing that? Even or how does something like that?
It's very gray and very fact intensive. One of the things with movie posters that goes even a little bit broader than just the copyright and the potential poster is the branding of the movie itself. If you're putting any words in your artwork, like let's say it was MGM or something like that, then you could get hit with trademarks no matter what. And then the likeness, let's say that there were actors or actresses in the poster, you're going to have to get around that too. So there's so many things that are intermingled together. Movie posters are very difficult because there's a lot of rights that lie there.
But so like if there's an art piece on an actor or actress of like a picture or a still from a movie or something like that, that the artist could potentially get in trouble for creating a piece that represents that person in that movie?
Yes. Yeah.
But and you're talking about from a particular piece though, not
I'm
taking a piece and not.
I'm just saying, I mean, I'm speaking kind of in broad terms in general. I mean, you see things of like Frank Sinatra in, like, there's tons of pieces out there with him, or Marilyn Monroe, or something like that, I mean, and I did a piece of a Spartan from 300. I mean, and it's dot work. It's not like it's not exact. So I don't know, like in terms, like my question was more just in the broad sense of can someone just like even Marilyn Monroe, you see pictures of her everywhere and branded on things
and they're extremely litigious. I will tell you that her house is extremely litigious. So the thing is that there are rights that you can have in the copyright to reproduce it, but it's her image, they feel, and her likeness that could be selling the piece, not your art.
Right.
That's the issue when you start talking about famous people. Okay, so a lot of times they're one that is very, very litigious. I know that they send a lot of cease and desist letters, and when you get into the merchandising, absolutely not.
I'm gonna be completely honest. I have no idea what that word means.
Merchandising?
No, litigious.
Oh, litigious. Oh. They sue a lot of people. And you don't want to be one of them. Yes.
The court gets a lot of money.
Yeah. It means they sue a lot of people.
Okay.
And a lot of times it is. It's a numbers game. It's like, am I going to sue? The reason that you see a lot of Marilyn Monroe stuff or whatever. I was like, merchandising. It's because it's a numbers game. Are you going to sue one person? Probably not. But as it becomes bigger and bigger,
if you're a brand
they will.
or something,
and if you're merchandising and selling it online, yeah.
Everybody here probably has seen Scott's rendition of Angelina Jolie, the fractured image, and I keep pushing him to send it to her because it's such an incredible portrait, but he won't because he doesn't have her permission to have done that with her photo, and he's afraid that this gift will turn into a lawsuit.
Right.
And so therefore we just demonstrate it as this is a technique that we
Right,
use.
Absolutely. For the educational,
For the educational,
which is
and
more
we
of
would
the
never
fair use.
we would never sell it.
Yeah.
Because we're afraid that she would be litigious.
Okay. Is that a G? Litigious?
Yeah, litigious, like instead of litigation, it's just like another form. It means that they sue a lot of people. Bob Marley, I could give you a big list. I know.
Probably all of them. They all
of them.
are
I mean,
looking
the thing
to
is, because when you're looking
sue.
at it,
That's all they got.
yeah, their rights last for a long, long time. I mean, the rights and their and if they came from California, that's why so many artists live in California. It's like 78 years. Every state, the right of likeness for the entertainers is state to state. Florida, that's why a lot of entertainers don't live here because it doesn't have as long of a right. But their families make money on that stuff. Martin Luther King's speech, that the family still makes money on the speech. There's a lot of different things that people don't realize.
But you would only sue your deep pockets, would you? I mean, you're not suing an individual.
No,
like
they
you were
sue
saying before.
everybody.
They sue everybody.
Depends. Because the thing with if they can tie it to copyright in any sort of fashion, what we have to remember with copyright that's a little different than the likeness laws is if they did get any sort of copyrights on anything, like the movie poster, let's say, it's statutory damages, and so those damages are $250 per infringement up to $150,000. So, and obviously you can't get blood from a turnip. If you sued someone that didn't have the money, what are they going to do? File bankruptcy. Yeah. But when you start selling it on the internet, it's so easy to find. Or putting it on a coffee cup or a mouse pad or whatever it may be. It's very easy for them.
They go after even a small fry, huh?
I've seen some small fries.
The flip side of it is you don't want
doing
someone that to you.
And
So
you're exactly right.
Well, I mean,
exactly
you can't
right. Good
play
point.
one game and not the other.
True.
Just out of curiosity, and I was just totally off topic, but like in terms of when artists, like musicians, remix a song, or or a cover or something like that, or anything like a DJ takes a song and changes
They're
it up.
supposed to be licensing that.
Mechanicals.
Yeah, so, I'm talking a lot today about art stuff because y'all are artists, but music is also something that can be copywritten. And one musical track could have, oh my gosh, like 15 copyrights in it, because you got someone playing the guitar, you got someone singing, you got someone mixing it, you got someone laying the beat, you got the producer. And if someone's sampling, like Kanye West, Beyonce, whoever's doing it and sampling the music, they're supposed to be licensing the rights of that.
Yeah, even people that do covers.
Absolutely.
That's the whole
Even-
thing. It's mechanical.
Yeah,
You've
and
gotta
I've
have
seen
a
it
permission.
even to where I've seen some guys and gals that play the guitar on the beach, like at beach bars. That music's supposed to be licensed that they're playing, and I have seen them get cease and desist letters.
Really?
Because either the venue, with the music thing, the way it works is the venue has the license, and that's why y'all hear the same like 15 songs or whatever, because that's the license that they have. And then if not, the artist needs to carry it. Karaoke, very litigious, very, yes, very, very much so. So, you know, it's just something that's kind of interesting. But that's copyright too, it's just a whole different realm. Sharon?
Okay, 2 quick questions. Okay, but if you're using somebody's words, like Shakespeare, you have a picture, and that's
Shakespeare's
what-
public domain.
Public domain, so anybody that you
Pre-1923.
can do
He's been
that.
dead a long time.
He has been. He has been.
That's why I
Not,
always
we don't
say-
count
I think.
reincarnations. Okay, my second question is more to, and you're probably gonna answer this, but this is where I ran into trouble. I was trying to figure out how to batch copyright a bunch of my pictures. Are you gonna be
Photos?
addressing that?
Photos,
My
yeah.
photos.
Um,
And I got confused on the site because it said they wanted copies, which I have no problem giving them copies, but then they said the names of
were
the
they
pictures.
are they published?
Not yet. I
Okay.
wanted to put them on a website.
Okay.
The poor person's copyright would just take the photos, put it into an envelope, mail it to yourself and never open the envelope. And the USPS stamp of that will serve if you ever need to go against somebody for going against it, using it.
It's
I heard that, and then I heard that wasn't really true.
It used to be.
It's not true?
It's not very.
Damn.
Not true.
No, I heard that wasn't true.
Stories are all over the place.
But there's something on the site when I
No,
go.
It's a good idea. It's a great idea.
It's not true. It's not true.
No, I know
But
it's not.
so it's not. There's something called a poor man's patent. It's the same thing. If I mail my, you know, explanation of my invention to myself, I can use it. You can't, and you just can't. Same with the
That's why
copyright.
we
But
hire
on the
professionals.
photos, I do. There's been a pilot program over the past 10 years. And as long as your photos are unpublished, which means they haven't been shown before, and
Okay, shown before in art shows or anywhere or?
anywhere.
Okay, see,
Your
I've
neighbor.
sold
I
some of
mean,
my
like,
stuff.
no, they're published then. Yeah. So it's still okay, but you have to do it in a different manner. You can only do so many of them. So I'm talking about photography. You can go to the pilot program and you pay one fee, which is $35 for the filing fee. And as long as they're unpublished and they were all taken by the same photographer in the same calendar year, you can upload all of them. And all of them will be protected.
All of
It's
them.
only
Can you publish that?
photos.
And you have
It's-
1 hour to download them, right?
Yeah.
They're
So,
not copyrighted, so
yeah.
they can publish them.
All of them for $35. So if you are a photographer, I don't know why they picked photography of all the different things, but they did. They came up with this pilot program and said, we're going to be okay with doing it like this.
But what if you've sold them in an art
If you've
show or
sold them,
something?
you can still do it, but it's called published. And I think it's like 250 batches of 250 or something. It's not unlimited.
So where do you
So-
get that pilot program? How do you find that?
So if you call the copyright office and ask about it, they're usually pretty. They'll talk to you. But when you're working through, like if you were to file electronically, you go to the little E. It's like a little ECO, and you click on it, and it asks you questions step by step, and it walks you through it. And if you hit photography, then it'll kind of walk you through. Okay, upload them. So I think you guys should organize them by the year and by a person that's snapping the shot.
So just a pilot copyright photo.
Yeah, I call it pilot program because it was a test launch that they did, but I haven't heard that they've stopped it. And I know as of like 6 months ago, it was still running.
It's there.
Yeah,
It's
so
there
it's
for
still there.
$35, but I got really confused with
The
where
thing
they were
is,
talking
yeah,
about.
so when they'll ask you, even if it's a painting that you're, you know, whatever it is, if you've ever showed it before, that means that it's been published. So just make sure that you check that box right. And if you haven't showed it before, then it's unpublished.
Showed it, okay, but.
You can show it to your family, that doesn't count, yeah.
If you send it to
Yeah.
somebody to show, but they didn't show it, then you haven't shown it. I know, that
It's
sounds
kind of
good.
gray. It's kind of gray, but I would say you're probably okay.
Yeah.
Probably, yeah.
See, I don't
Okay, now you
remember
take those
which ones are
photographs
sold.
and you put them in Photoshop and you manipulate them. Are they still considered photographs?
That's also very gray.
What is the question?
How much of the photographs are the images still recognizable?
No. In my case, no, but I'm going to take it in steps, okay? If you
Okay.
manipulate them a little bit, they can still consider photographs.
Once upon a time,
sounds like
it was
sculpture.
like 30%.
Yeah, there's not a black and white rule of 30%, but what I like to look at is, are they recognizable? So if it's a little bit of manipulation, then I don't think so. If it's more, then you should be safe.
So they're no longer considered photographs at that point.
Right.
No, your stuff is
Not
not
yours, though.
photographs.
Yeah, because I think, it sounds like yours is not.
Because I've never heard anybody defining that to be recognizable was the criteria.
Yeah.
That's the criteria.
Yeah, recognizable is what they're saying right now.
Okay.
And again, every jurisdiction has something different, but that's what I like to think of as the recognizable.
Yeah, because in my work, I wanted to be able to get away with the $35 and download it for an hour. But now, since they're not considered photographs,
So what
I would
is
have to
it-
go. I would have to copyright each
So
one
what
separately.
do you do? Like, tell me what do you do? What's your
My
art?
photographs are really abstracted so much that you never
Well,
didn't even know
digital
what the
art.
photograph was originally. you know?
Yeah, I think you'd have a hard time. They're gonna let you do it, because the thing is, y'all could put in whatever you want, and the copyright office is gonna stamp it and say copyright granted, because they don't review it.
Oh,
That's
okay.
just how that. Unlike the patent and trademark office, but if you go to enforce it, like let's say you saw someone using it online and wanted to sue them, then they're gonna say that was never a valid copyright. The other people on the other side. That's the easiest way to
But
get away
yeah,
with
this
something.
started as a photograph, but that one cut it because it
I don't. Yeah.
okay no longer looks like the original
Yeah.
image. Okay.
Yeah.
But are you taking other people's photographs and doing that, or
Oh,
you're?
I can take a photograph of my work and do it that way. How's that? Yeah.
No,
I
'cause
I
you're
did the
protecting
abstract,
the
a photograph, my
photograph.
abstract, and I got
You're
a photograph.
protecting the
But he
photograph.
really wants to protect his image. The
He
image
wants to
should
protect
be-
the image, but he doesn't want to pay $35 every time he does it.
No, the
For the
$35
registration.
tells you for 1 hour of download time, you know, so you can do a lot of images in 1 hour of download, okay? So yeah, so I print my image, I photograph it, then I have a photograph of the image, and that's my copyright. No?
Yeah, I guess that could potentially work, but I don't know what your art looks like, so I'm trying to envision
It's really
it.
abstract. In other words, if you were to look this at a house, and this, you would never know it was the same photograph. You know?
The safe way is no, unless it's an actual photograph, don't do a bunch
He
of
takes
them
the picture
together.
and leaves the cover on the camera. And
Yeah, right. Thank you. Thank you. Yeah. Or if you take one picture of the
It is
photograph,
that far
art
removed
brush
from
and
being a
paint, and we're gonna make it look like
one pixel
what
is
I thought
actually the
it
original
should be.
photograph. You know.
Yeah, right.
I'm sure it's great
So
stuff.
like me, as like oil painting, I have to pay $35 for each photo, for each painting to be.
Yeah, that's why I said, I don't know why they said photos. I mean, I get it kind of because there's a lot of photos taken where an oil painting takes a long time, to make, but that's just how it is. There's no pilot programs for any of that. The copyright is affixed as soon as y'all create it, right? You guys know that. So you have the copyright, but you can't sue anyone until you file for federal protection. And that's very important because let's say that you create the copyright or you create your work and it's copywritten essentially, and then you go and you put it in a gallery and then someone starts infringing. Yes, you can go back and file for the copyright protection, but you've already published it, so you lose your opportunity for those big money statutory damages.
Whoa. Now you're scaring me. I have a painting that is in a museum that I have to get copyrighted. Is it too late?
You can do it, you just have to do it as a published work.
Okay.
But if someone's sued, you don't get the benefit. If you needed to sue someone, I'm
It's
sorry.
already been there for like 5 years.
You don't. It's okay. You can do it whenever you want, but you don't get the benefit of those big $150,000 damages. You would have to prove what's called actual damages.
Ooh.
And if you wanted an attorney to take it on contingency, which means you don't pay out of pocket, the attorney makes money on whatever you win. They want to know that you have a federal copyright because they're not going to take the case if you're going on common law rights.
Yeah.
I better get it done like soon.
Nice.
Yeah. Yes.
I want to ask, I have been doing some photo collages, but I've been using my photos for it, and I've kind of exhausted it, and I wanted to do photo collages using images from magazines. Is that some kind of copyright infringement?
That's typically, and again, it depends on how recognizable it's going to be when the collage turns out. But the law right now says that's typically okay. But be very careful of the brands. That's the thing that I get very afraid of, is if there's any sort of branding or logos or insignia that are in the magazine. If it's just images, it's one thing, but if it's any branding, that makes me nervous, because that is a very different area.
I want to recommend that you can go to a place like Deposit Photos.
Yeah.
Which is you purchase royalty-free images, and they have so many brands available.
Yeah.
But those images are permittable. So, for example, we're doing a client project, and we need every sports team in Tampa, which I thought was an absolute no. But after doing research, these royalty-free images, you have permission to use these as long as you pay whoever it is that you're buying the image from.
Yeah.
And you can buy bunches. I actually bought a Groupon with Deposit Photos. I spent $30 and I get 1,000 downloads.
Yeah, that's a really good
Groupon. That
point.
was one of my smarter buys.
What's it called, Julie?
Deposit Photos?
Thank you.
Sure. So
Yeah.
if you're looking
So pictures
for
like from
images that are-
NFL or NHL or whatever, they have some out there that you can.
Yes, just like that. That
Download
was a really
like
good
that.
point that Jerry
Yeah.
just
The other
made.
point is if you do a search of Google Images or TinEye or something, you can search by license, and Creative Commons you can use, or you can also search by license modified with reuse or available for reuse, and that will show you only the images that are copyright acceptable. So when you do
can get
Google
those
search,
and then you can
TinEye
make them
search,
abstract.
Yeah,
be
sure.
sure to check those boxes, because it will limit your search capabilities, but at least you know you're within legal ramifications.
Yeah. Another thing I wanted to say real quick is, does anyone know what the DMCA, the Digital Millennium Copyright Act is? It's a really, really cool thing. So if y'all were to see your artwork up anywhere online that you didn't authorize, you don't have to have a copyright registration through the Copyright Office, but you can do what's called a DMCA takedown request. And it's DMCA. There's companies that'll do it for you, lawyers will do it for you, and it's not terribly expensive. The cool thing about that is not only does the DMCA go to whoever is running the website, the business, but it goes to the ISP, which is the Internet Service Provider, and they have to take it down. And then at that point, then the people that own the business could say, well, I thought I had a legitimate right to put it up, and there's a back and forth, but it's a very good thing. And what I wanted to say about that is if y'all put a watermark on your artwork and someone snips it or crops that watermark off, that's a $2,500 fee just in and of itself. So there's other things that you can do to protect yourself. Yes, filing for the registration is one thing, but if you don't have the money to do $35, you can do other things that will really help.
Added on to that, we licensed a number of Scott's images a few years ago, and then all of a sudden we found them on the Sears website and the Walmart website. So I sent out cease and desist letters under that, and they took them down.
Yeah.
So there are people who will find images that are on certain stores, and they'll just swipe them, and they'll put them on their stores, jack the price up 10 to 15%. So it's really, really useful.
It's very
Don't be
useful.
afraid of these cease and
Yeah,
desist
it's
letters.
very, very useful.
So, let's just say you have a picture of artwork or a photograph or whatever the case may be on some type of social media, and you have a watermark in the corner. Somebody reposts it and crops out your watermark, doesn't give you any kind of recognition or anything like that. Whether they promoted themselves if they did it, or they try to sell some form of it, or whatever, or they're just posting it just to post it. Like that $2,500 that like
You could sue
you
them.
could sue him for that.
Yeah.
That's something that you could be like, yo, you posted my work and you cropped my watermark out. Like,
Yeah. And the fact that they gave you a credit or not, it really doesn't matter in the copyright world. People want money and they don't care about credit in the world I come from. So it doesn't, that piece doesn't matter. Now what you can do is just the act in and of itself. By them cropping it, they're liable. But obviously you're gonna have to get an attorney to help you with the suit. And if you just had that one instance, it may not be financially worth it,
Right,
you know, because
right.
it's probably
You
going to be
could
a
get
$5,000
litigious.
retainer. It could be, yeah. But once you send them a letter saying that, or even an email that, hey, you cropped it, and by this, you could be liable for that, most of the time they'll pull it down.
interesting. So, in terms of, like, even reposting somebody else's artwork, like, let's say you have, like, you're
be
just, like,
very-
some kind of, like, inspirational quote or something like that.
Yeah.
You post on your own personal account, if you, as long as you, like, let's just say, or message them and be like, hey, can I use this
Yes,
you've got?
if you-
That's cool, and they say it's okay.
If you have their permission, but if you just said, I got this cool quote from Maya Angelou, you know, Maya Angelou's heirs don't care that you gave her credit. That's what I more mean by that,
yeah.
you know what I'm saying? But if you have their permission, that's something totally different.
Okay.
But also be careful when you're posting that, you know, maybe it just doesn't look as cool with the little watermark on it. Don't crop anyone of any, don't crop, because they can send you a letter.
So even if it's quotes, so if you're
So quotes they're all a little different. Most short quotes aren't protectable because they're just not. But if it's a little bit longer, then poems can be protectable. Okay? So it really depends on does it have protection or does it not. But you can always go to the places that Jerry was talking about and make sure that, you know, you're licensing them or something of that nature. Same with any music that you're going to put up on any websites at all. Yeah, I'm seeing tons of very litigious things happening there.
I was out
So like, if I do a piece of art, I have to put a copyright mark on it next to my name, do
You don't
I?
have to. You don't have to. You don't have to have that notice provision anymore. But if you wanted to get willful damages, then you would need that. And by willful, I mean if you tried to sue someone and said, "Hey, I had a copyright on this," they'd say, "Well, I didn't know, you didn't mark it." And then they would be called with an innocent infringer. But if you mark it, then it's like, I marked it right here. But I get it. I know a lot of times people don't want to put that kind of stuff
It's
on
just
it.
so like anti-tradition.
Yeah, I totally get it. So yes, you can still sue, but you just don't get those. Now, if they worked for you and there was like more background behind it that was factually intensive to prove the willfulness, that'd be different.
In music nowadays, they do sampling of.
Yeah, absolutely.
Yeah. So let's say you sample. The way I understand, even if you sample 1/10 of a second, you still need permission.
Yes.
You still do.
Yeah.
But not in the montage though. You don't. He says he can do that.
In the magazine.
You can cut an
Yeah.
image from a magazine. It's okay, but you cannot cut an audio.
Yeah.
There's a difference between the two, huh?
Yeah.
But there are websites where you can go and get
Yeah.
royalty-free music.
Yeah, there's a difference between the two, and with the music, there's two houses that own almost all of it, and that's the difference. Is they have a lot of money and a lot of power, to where with magazines and newspapers, they're all owned by different people. So that's just a little bit of a background and aside. But those two houses, they know what music they own, just like with Prince. Prince worked his whole life to try to keep his music out of places he didn't want it. Like YouTube was an example. Have y'all heard of the Dancing Baby? Yeah. So, you know, it was just played in the background and he still sued.
Yeah, but I'm talking about 1/10 of a second. Okay,
No,
you wouldn't even notice it. Okay.
No.
If you don't notice it, then yeah, it's
Yeah.
okay. But
I mean, of course, 1/10 of a second. Usually, what happens, you would multiply it 100 times. All of a sudden, you're making use of it.
noticeable,
He's
it's
very
okay.
creative. He'll take a sound. Like if he takes a song and he told you that he took something from it, he took a sound that was like up, and then he took that up and he stretched it
Like
out.
stretched
like,
it.
And he does like.
then I think that would be fine.
Pro Tools.
Yeah, I think that would be fine.
You would be
'Cause
fine, but
I
if you were the
couldn't-
judge, what would you do, though? You see it.
Well, if it
How would
was
you do it?
like,
Fine, no one will
is there a
ever figure it
famous
out.
song that's like,
Yeah, the Prince song. It's like,
What?
you know, that'd be the one.
It depends on that.
I actually spent the day yesterday, someone came to videotape me for something we're gonna put online, and I had some music I was gonna play, and she's like, uh-oh, wait a minute. So we spent like probably a good half hour looking on YouTube and just looking up non-copyrighted music, and there's a lot of non-copyrighted music out there. So we felt very safe about using, you know, the music that we play, because it's, so there's music out there.
There is music out there, and just always look at the terms of use and the terms of service. So just be very careful. But music's art too, you know, it's just a different medium.
My question is a little different. If I have a bunch of lyrics, I don't have the music for it yet. Now copywriting that, how do you copyright the lyrics?
So you would copyright that under a literary work,
right?
Because it's literally, you know, right now it's the lyrics. So you would just, it's $35, and it would be under a literary work.
But all or individually?
All, each song individually. Yes.
Could you make like one huge piece?
You can definitely do that, but then you have to think, let's flip the script, and if someone took one of the songs of the 25 that you did, wouldn't you want to sue them?
Yeah.
And so it's only 1/25 of the entire piece.
Right.
So it's not really the heart and soul. You know, that's what they look at. So the more that you try to pack in to get it cheaper, the more you're watering down your rights. It's
It'd
just
probably be
not
like
it.
poetry.
Yeah,
And,
I mean, that's just the fact of it, except with photography.
So the other part of it was to, if I wanted to use parts of those lyrics in artwork, is there a problem there?
No, and they're your lyrics?
Yes, it's my
Yeah,
lyrics.
you're good.
Should it be copyrighted first though? Of course I think.
Yes, because I'm an intellectual property attorney, so I say yes, because I want to be safest. Yes.
So in other words, his lyrics are actually, the lyrics posted as a painting.
Yeah.
And take a photo of it.
Yeah, it would be published. I mean, once, if you didn't do that, if you went ahead and did your art, then you wanted to do your lyrics, you know, register them, they'd be published at that point. And then you lose your damages. You go back to what we were talking about earlier.
So copyright them first and then use them in the art. Okay.
And then copy your artwork so you CYA.
Yeah.
So
Check.
would you, I'm just building my website with my photographs, so would you suggest
Who's doing your website? Who's writing? You write code?
No, I have somebody that's doing it for me.
Do they sign an agreement to make sure that you own everything they're doing?
Oh, I don't know, but I'll do that. But we're doing it together, so I can actually manage the site.
Still have them right
Okay. So would you suggest that I watermark the photographs that I put on the site? So,
And it doesn't have to be some big, you know, crazy looking watermark that's stretched all over. It can be just something nice and small and tastefully done, and really that's a better way to do it, because then if they even snip a little, you've got them.
Right.
Same with your question on products. You know, you can always take photographs of the products and watermark those as well if you were selling online, and if anyone grabbed that, you know, then you can get the same types of damages.
Yeah.
So we do a lot. A lot of our clients sell products, and we always take photograph. We always make sure that we've got copyright protection on the actual photographs of the products that we're selling to layer the protection.
Yeah. No, the other thing that I do is offer two of these items, a rocking horse and a scooter coat, as kits that people can assemble themselves and put a finish on. So, because with the internet, you know, to have a 36 by 35 rocking horse to mail it to Germany,
right? It's pretty.
You're not
cost
going to do that.
effective,
Yeah, and so, you know, that's another thing is with the kits, they're not assembled at all. The best I can do with a picture is to show the appropriate sized box, and then the pieces laid out, you know, on what the kit is going to include. So how does that, again, is that just taking a picture of it and then before, and should it
just put the watermark on the photo, you know, some sort of watermark or identifier. If you anything you're selling
can you do that
online.
after the photo or
yeah, after the photo with software. You do it with different software.
Okay.
Yeah.
Okay. Yeah. So, because Scott's doing all my pictures, so
cool.
He can
do it.
He can do that. Yes.
As long as he doesn't sell the photos first.
Oh, there he is. Hey, Scott.
It is 8:40. To keep going. It's 8:40. Are we good on time? I wanted to make sure. I don't want to run you late.
We promote that this goes until 9.
Okay.
If
I'm
your
good.
voice is willing to hold
No,
out.
I'm good. I'll continue to answer questions.
Okay, on additional work, the metadata, is that that's legal? You can put your copyright there, and that would be the legal way of saying this is copyrighted. Okay.
Yeah, you know, it's different tagging essentially with the metadata and things.
Okay.
So yeah, it's just it's a new thing. The DMCA is not new, but the snipping of the markings is a rather new piece, and it's just another layer of protection. You don't have to have the copyright registered, so why not do it? And then if you find your photo, you know, somewhere that you don't want it to be, you know, on Walmart's website or something like that, you have some, you know, some grounds there.
So, let's say okay, you're a photographer, right? And you have your camera puts in your name into your photos, and it goes into your metadata immediately.
Mm-hmm.
Let's say you have somebody else press the shutter on your camera for you. You set the whole shot up, and you gotta like run a light through like your light painting or something. You have somebody else push it for you. Do they own the rights to that?
The way copyright law works, they do.
Shutterbug.
Yeah, the only thing that doesn't is the monkey.
button.
You know, you heard about the monkey
Yes.
that took the selfie?
Yes.
Yeah.
They
Yes.
said animals can't own the copyright, so the photographer did.
I wanted to throw out that there's ways to put your name so that if any of your images come up, you get a notification of it.
Yeah.
So if you're not familiar with it, that's good information to learn about.
Yeah.
There's
It's just a program online that does it, or
Through Google, right?
It's Google Alerts, is that what? Yeah. So Google Alerts, Google is a free, Google Alerts is a free thing. You just go into the toolbar, type in Google Alerts, and you can set different campaigns for your name. You know, that way if you get good press, bad press, whatever it may be, it sends you an alert, and it crawls the web constantly. So it really is a good thing to set up.
and it'll search metadata and photos.
It does search metadata. It does.
Cool.
Yeah. I know that there's blockers. I know that there's, you know, ways around it.
Yeah, there's ways you can strip that from the
Right.
photo too.
But it's for free. It's a pretty good thing.
Yeah.
You know.
Can I just go back to what
Yeah.
you were saying before? So if you do the batch photograph,
Google Alerts.
that's totally unpublished. And if it is published, then you have to do each one individually?
If it is published, there's a number. You can still batch them, but it's not an unlimited batch, and I don't remember what the number is off the top of my head. So you go call the copyright office or go online. I think it's 250 photographs.
I don't know
So-
that many.
Yeah, something like that. It's still a good number, but it's not unlimited.
Okay.
Thank you.
Anything else?
Are you enough?
I'm good.
So Brittney's going to share her slides with us, and this has been, you know, she said I entertain questions and answers.
Yeah,
And
I
so-
think I've covered a lot of them actually.
Oh, you have.
So
You've done a great job.
I'm
Thank you
yes,
very
a
much.
lot of them. Let me just look really quick. This is a pretty interesting one with the Visual Artists' Rights Act. Did anyone hear about this? Ed Ruscha Monument? So Kent Twitchell, it was a settlement. He created the 6-story mural, which they're calling Ed Ruscha Monument, between 1978 and 1987, on a federal government-owned building. I don't know if it was commissioned. I don't know all of those kind of things, but he sued the U.S. government and 11 other defendants, including contractors and subcontractors, after they painted over the mural in June of 2006 without his consent. And the lawsuit actually settled for in 2008 for $1.1 million, and it constituted the largest settlement under VARA, in combination with the California Art Preservation Act. Now, that is a whole nother ball of wax, but it's something to just remember. Florida, you can couple the VARA with different state law, and California, just by its nature, is much more liberal in some of its protection of artists, entertainers, musicians, those sorts of things. Florida does not have anything like that.
There actually, a friend of ours, Dakota, actually posted yesterday about an artist who did a mural on a wall in St. Pete.
Really?
And there are new owners that are taking over the building and they wanna paint over her mural. And so there's a whole big thing going on with it.
Really?
Get a phone number.
Yeah.
She wanted to be here tonight, actually, so
Because sometimes the news calls and they'll like ask for my comment, and so like, and I can't sit there all day and read stuff.
Oh, and
so.
she was asking to,
What building
for us
is
to
it, do you know?
email the artists,
Okay.
and, which is actually something I did, but I can give you the name of the artist and
Okay.
you might wanna I think
There's
it's
so many,
Carrie.
it's
Yeah,
eight.
yeah.
Carrie.
Jadis.
Jada.
J-A-D-U-S.
Yeah, and I can give you her
Okay,
email.
cool.
I think it's
She's a local mural.
cjada@gmail.com, but
Okay.
I'll find her email address for
Do you know them?
So do they have the right to sue the contractor? They have the right to sue, even if the contractor had nothing to do with the painting or anything like that, and was just going in there to,
So-
got hired to
Paint a wall.
Yeah.
not paint the wall, anything, had nothing to do with painting, was just doing the interior work of that building.
Yeah.
Can they sue the guy that was, did nothing to do with that painting, was just the contractor for the building?
Yeah. So anyone can be sued at any time for anything.
We're so litigious.
That's the
That's
very
scary.
blunt
So litigious.
and really, and if you're looking at a lawsuit or gearing up for one, you're literally looking at all the pieces and trying to bring in as many people as you can. Do they have liability? Probably not, but they still could get sued. You know, they probably would be able to get out of the lawsuit easily, but anyone again can be brought into a lawsuit. And if they were a part, any way, shape, or form, they'll probably be brought in.
Well, and the thing here too is that this is an act, a legal act of the California legislature
Right.
that created this. So, you
And-
know, if someone's doing plumbing inside the building and someone else is painting over the mural, then, you know, the plumber isn't gonna be held liable. They may be named, but by describing the work they do,
Right.
that has nothing to do with destroying the image, then
Let's see what happens.
they would probably be, you know, excluded from that. But, so, this was and the other thing, does the California Art Preservation Act, is it only on federal government buildings? Or does
No.
it
I
apply
know
to
the answer
private
to that.
buildings?
It's private buildings as well, but that's as much as I know about
Yeah.
it. One thing I want to say about VARA, because that's the Visual Arts Right Act, which is more of Artist Right Act and more of what y'all would be looking at, because Florida doesn't have the Art Preservation Act as a state law, is VARA applies to authors of joint visual works as well as co-owners. And it is narrowly defined to distinguish visual arts from other forms of arts. It protects the right of attribution, the right of integrity, and the right to prevent destruction in visual arts, defined as painting, drawing, print, or sculpture. However, it does not cover posters, maps, globes, charts, technical drawings, diagrams, models, and applied art. So obviously, you know, that's just a little bit more of it. It's a pretty interesting piece. Yeah.
So, in terms of murals on walls, photographer taking a photo of a model or of something interesting, and there's a mural in the shot, and then you sell the shot. Do you have to get rights or licenses from the artist who
Did the mural.
So what if it's something like Maxey, who does illegal artwork on, like, just how does that work? You know, there's T-shirts of his
What,
artwork.
I don't know who that Banksy
Oh, he's a
was.
famous
Graffiti artist.
Okay.
artist.
Okay.
He's been arrested multiple times.
Yeah.
But he's like world known.
Yeah.
His
I have
pieces are all over the
something
place.
here
But
on
there's
graffiti.
shirts. Like I own a shirt that is a rendition of one of his pieces. Could he basically sue the company who's selling his artwork? Like his artwork is.
I do think, because the difference is it's still with the merchandising. The shirt itself, there has to be a license agreement there. He
even
has
though
to
it's
be,
illegal artwork.
Yeah, it's still,
Yeah.
it's still
Whoever made the T-shirt
copyrightable,
had to have a
you know.
license
You
to
know,
put
if you
that
turn
on.
it around and you think, well, what
Yeah.
if it was my work?
But
I
I'm
have
just thinking like in
some-
terms of
Would
taking a
that
picture of
be-
graffiti on
Yeah.
a wall.
I mean,
you know, like
and
Because
some people
I
don't
do
care.
have
They
some-
just make them up and sell them.
Well,
Hundreds of thousands of them.
It's graffiti.
So I had this on graffiti. I don't know a ton about it. I'm gonna do this.
It was cheaper.
So
Okay,
this was graffiti art.
And they quit making it.
So typically, cities can remove graffiti art freely. However, even St. Peter's looking at maybe making some changes there. They're trying to do all of the underpasses. There's a lot happening there because graffiti is really becoming quite big. But this one, for instance, is when graffiti art titled "Slave Labor Blunting Boy." I don't know why.
This is Banksy.
This is
who
Banksy.
she's
Oh,
talking
this is the
about.
Banksy.
Yeah.
Oh,
Yeah.
look at that.
Yeah.
Okay.
She's so prepared.
Okay.
There you can see his name right there.
Oh, there we go. Okay.
Yeah.
So it was removed from a London borough. It was seen as a unique for the social impact and importance of the artist Banksy. When it was set to be sold in Miami, due to public outcry from London, it was removed from the auction, and it was ultimately sold for $1.1 million. So that's a little bit of information about it, but graffiti art is very gray right now because most cities don't look at it as an art form, but apparently Banksy is different. And I wonder if he licensed their shirts, because I wouldn't think he would, unless he was making money on it. Let me see what else I've got. This is a little bit more about public art, and I'm sorry again that the fonts and stuff are so strange because the way I downloaded it. Can a city prevent others from photographing and profiting from public art on display in a public park? Yes, selling physical works does not mean artists part with their intellectual property rights. If someone wants to sell copies of artworks, it must purchase the right to do so. It makes no difference whether the items are on public land or created for a public client. Y'all know the Bean thing in Chicago. They got a gallery got very angry when they were told they couldn't make postcard images of the Bean.
They had one in Hong Kong too.
Yeah.
Interesting.
So, and it is a clash. It's a clash between First Amendment laws and copyright laws. That's just an
How about if you
aside.
just photograph one square segment of it?
Yeah,
You would do that.
that's for sale.
As long as they can't tell what it
You
is.
can make it into a moccasin.
Hi.
So the 1.1 million
Abstract
that
bean.
was awarded, how much does the artist get?
So it depends on.
You're asking a lawyer, that's not very nice.
Well, it depends. If the case was taken on contingency to where he didn't have to pay any money, then he got 66% because you get 33%. But I don't know how it was taken. So
Okay.
yeah.
That's a guideline.
No more litigious questions.
One more question. Okay.
Really quick. Okay, so if you use one of those website builders that are online, I don't remember the name of it, but
Yeah.
there's a couple of different
Yes.
ones.
Uh-huh.
You still own your copyright, or do they
have to
own
read.
it now?
So if you're using something online or by a human individual that's creating it, you have to read the contract. So you need to click on the terms of use or terms of service, and it'll say where most of those are retaining the intellectual property rights because they're templates and they want to sell them to you cheap. It's more of a mass market type of thing. It's like, I'm going to let you use it for cheap, but I'm going to let a lot of other people use it too because it's not custom. That's kind of the blunt.
So it's like
Yes.
WordPress
Yeah.
and GoDaddy
Yeah.
and things
Yeah.
like that.
Right, but, you,
ask the Facebook question?
Yeah,
but then they still own it?
Yeah,
It's the same one.
They own
they
the
own it,
copyright?
but they give you the exclusive license to use it.
Oh, okay.
So, you know,
Okay.
It's almost like buying a domain
yes. Okay,
where
Jerry.
no one else
Thanks for
can
your
have
question.
it, but you gotta pay
We're all
them
thinking the same
to
question.
publish
Well,
it.
I was gonna ask,
When you post a photo on
Thank you.
Facebook, does Facebook take ownership of it?
Facebook
they do.
doesn't own it, but they get an implied license to do anything they want with it.
Oh,
whoa.
But that's better than what has been
Mhm.
talked about in the past, which is if you upload something to something like a Facebook, then they get ownership of it.
Right, yeah. It's not, you still retain the ownership, they just get the, you know, and they're not right now at this point gonna go into the business of merchandising and that sort of thing, but you're giving them an implied license.
they have as many rights as the owner, in other words?
They don't have as many rights, it's an
I mean,
implied
they probably
license
can't
to
sell it,
use.
can they? I mean,
Yeah.
well, we don't know.
So if you use your Facebook page, like a business Facebook page to post pictures of your paintings, they don't actually own any of it.
They don't own it, but if they wanted to pull some of those pictures of your painting and put them somewhere else, they could.
Whoa.
And you couldn't do anything about it.
Like
That's the,
advertising.
yeah, that's the implied license.
So
Well,
even
but
a
they're-
watermark or anything else on
they're
it is
not-
not gonna make a difference.
No.
But did they allowed to sell?
Because
the
you've already
work, or-
intentionally posted it.
So yeah, because their policy is very interesting on Facebook. Now I will say Facebook is very liberal. It's very difficult to get things taken down off of there, but Instagram, if you can prove that you've got the copyright or the trademark, they will pull things down. So that's another good thing for products, because so many are sold on, watermarking and on
They're
Instagram.
technically owned by the same company.
Yeah, I know, it's very interesting.
I gotta dip, but
Okay.
thank you so
Thank
so
y'all.
so
Thank
much.
you
So-
so much.
Yeah.
Okay. Very good.
I don't
Also,
work
this
for
one-
somebody else. I just have
Did you have a
to
second
go.
business card?
Yes, I think I do.
So we're gonna pass out Brittney's business cards. She's very, very reasonable and great person to talk to. She'll stick around for a very short time, but if you have questions and or if you have any friends that have questions, are interested in applying for patents, copyright, trademarks, her office staff
or whoever
people are
wants to
wonderful to work with. So thank you so much.
Thank
and
y'all,
you
and
for
thanks
being
for
with us.
bearing with me when I'm not feeling great. I'm usually much more